Thanks for staying with us. Now, the Achimota forest remains the biggest tract of prime land and ecology in the Greater Accra region. Now, many of us may not be die-in-the-wool environmental lovers, but at least one thing is certain, we do know that protecting forests is critical. Now, according to the Food and Agricultural Organization of the UN, Ghana is one of the tropical countries with the highest percentage of rainforest loss in the world. Ghana's current forest cover stands at 1.6 million hectares, about 4 million acres, and that is down almost 80% from 8.2 million hectares. That's what we started off with in 1900. Now we are left with 1.6 million, and that's from the Ministry of Lands and Natural Resources. The question is, what is government's commitment to preserving what will remain of the Achimota forest? Let's hear from the Honorable Abu Jinapo following the decision to declassify the area as a forest reserve.
Did indicate in the final paragraph, in order to motivate the discretion of the president to give approval for us to proceed as we've done, I did indicate, and I quote, the ministry intends to develop the forest into an ecotourism park along the likes of Central Park in New York or Hyde Park in London, end quote. So by all intents and purposes, ab initio, we always intended to rather upgrade the Achimota forest into a forest reserve which is fit for purpose, which is befitting of Accra as the capital of our country. Achimota forest has not been sold, it's not been compromised, it will not be sold, it remains as it is. We will continue to reforest the Achimota forest, and God willing, we intend to develop the Achimota forest into a true forest reserve which will serve Accra and the people of Ghana.
Now, is it the case that this isn't the only issue and that this is not just about the environment, that it's about suspicions of an overt grand scheme for senior public officials to benefit from what is the last natural prime land in Accra? Now, land is always a sensitive issue in capital cities across the world, where indigents always feel hard done by, pushed out, and excluded. And that is why it seems this 2-decade-long campaign by the Owu family has persisted. Let's hear from their lawyer, Leon John Edusei.
Requested any acreage of government. What we have been doing is negotiating with government with a view of them returning land to us. Now, at no time have we been offered 90 acres. In fact, I think you are referring to 90 hectares, which is 194 acres, which was the original offer being made by government when we were in negotiation in sometime in 2008. Since then, certain factors have come into play, which has necessitated changes along the line. And due to certain changes and withdrawal, land being taken back for government, this has brought that increment, and these are usually due to various financial and ecological reasons. That's why these figures were changed. But we've never asked for a precise amount of acreage, and government has never put anything in stone, setting in stone, none of the government. We're not going to be building concrete monstrosities there. But what would be done would be in tune with the whole green concept. We've already started planting trees there. About 10 years ago. With our then partners, we paid nearly 2 million Ghana cedis to start planting trees. Because if you have gone to the forest today, you yourself will see what exactly that is.
So that's the lawyer for the Owu family. But there are concerns about, protecting that enclave, and that once we declassify it, we open it up to land hunters. And so should that be the reason why we give the land back to the Owu family? Why not pay them compensation? Because the view is that the Achimota Reserve is serving as an ecological and environmental facility. We recall how lands along the motorway had been rezoned and returned to allodial owners because we weren't expanding the motorway in line with what that land was for. and therefore we saw encroachments, and now we see what the impact is on that whole area and even the natural ecology. So what next? I'm still in the studio here with the Honorable Andy Apiakubi. Thank you for staying with us. We will have on the phone lines the Honorable Inusa Fuseni, who is a former Minister for Lands and Natural Resources. On Zoom, we have Dr. Godwin Jah, who is an environmental lawyer with the York University in Canada. He's a fellow of a college there. And then we have in studio as well Elvis Opong, who is the spokesperson for the Coalition of Environmental NGOs. So thank you, everyone, for joining us this morning. Much appreciated.
Thank you.
All right. So let me start with you, Mr. Opong. What for you is the reason, or what is the cons against holding or declassifying the Achimota forest?
So let me take this opportunity to greet your valuable listeners. No, so this is not the first time this Achimota discussion has popped out. When it started first, a lot of people made a case for why we think they should not be declassified, and we think those points are very relevant, especially Honorable Osafo Maafo gave reasons why he thinks those days why he thinks the forest reserve should not be declassified. And I think just recently, Kwabena Japan, the former General Secretary for NPP, we all know that he's also an environmental engineer.
He's an engineer,
yeah,
but
exactly.
Not an environmental engineer, but he's an engineer. Yeah.
So he has also made a reason why he thinks the forest reserve should not be declassified. And it's very and whatever he said for us, we think is very true. Achimota Forest Reserve happens to be the only green belt we have in Greater Accra. And that green belt serves a very important purpose. It's not just by coincidence that you realize that when flooding happens in Accra, most part of Accra, you don't see flooding in that part of the country, or that part of Accra. It's because of the role that the forest played. In most parts of Accra, we have just cemented the area, so when the rain falls, it all comes back to the streets and it leads to flooding. But because of that part of Accra, the Achimota forest and the size of the land, when the water falls, the forest tries to absorb the most part of the water that flows. So it's reduced the possibility of flooding happening in that area. Apart from Achimota forest trying to reduce flooding, one critical important that forest play. Back at secondary school in Achimota, we were told about how the functions of tree, when tree absorbed carbon dioxide and breathe out oxygen. Accra is a very polluted city. We have a lot of industries, we have a lot of cars, and we pollute the atmosphere so much. And it's the function of the trees that absorb those dangerous chemicals that we put in the atmosphere. And like I said, Accra, the only one that we have is Achimota forest. For us, we even think we need to have more of Achimota like in some part of Accra, because the kind of chemicals that we are releasing to the atmosphere, Achimota forest alone cannot even contain it. But at least it's playing its role as it needs to do. Once that we try to reduce the size of Achimota forest, we are expecting more carbon dioxide to be in the atmosphere. We all know, the science people will tell you the consequences of when these chemicals are in the atmosphere. That's the reason why we think it does not make sense for us to reduce the size of Achimota forest. Apart from that, one consequence that we are overlooking as people is the consequences of declassifying Achimota forest in forest management in Ghana. We believed that if the president's EI stands, it will lead to chaos in forest management in Ghana.
So this is apart from what may happen at the Achimota forest, there might be the risk of other forest reserves coming under attack.
Exactly,
that's your concern.
Exactly. Okay. Exactly.
But hasn't that already happened? We have a Tiwa forest that, there's a lot of encroachment. You go to the western region, you see a lot of felling for galamsey and also for timber. The same in Ashanti. There's still lots of forest cover, but there are threats.
No, so it will move from just encroachment to people trying to demand the land for other purposes. Let me try to set the basis for people to understand this. There are two major ways how land are acquired for setting a forest reserve. The first process is when government need a land for forest reserve, government can talk to the landowners and compensate them and take the land for forest purposes. In that sense, the land belongs to the state and the state manages it. There are other ways whereby government acquire the land without paying compensation, which the law allows. I think Cap 157. It allows that government acquire the land without paying for compensation. But government manage the land for the people. And when there is a revenue out of it, government pays royalties to. So when you go to most part of the Western Eastern region, that's why when they cut down timber trees, government pays royalties to the people. When you listen to the Achimota discussion from the press statement, from the EI, it gives you the indication that in 1921, when we acquired the land from the family, we paid compensation.
£4,000.
Exactly. So for that one is settled. But in 1927, from the minister, we did not pay compensation. At least there's no evidence of receipt of payment of compensation. And I think the family lawyer also did mention that they did not pay compensation. So what it means is that the second part falls into the category of forest reserve, whereby government manage that portion of the forest for the people without paying compensation, which is allowed. This kind of category of forest reserve is made up of more than 80% of the forest reserve that we have. More than 80% of the forest reserve that we have in Ghana here are managed by government for the people without paying compensation.
But they are not all in the capital city. And you and I know that historically, capital cities tend to suffer. Indigenes of capital cities always get pushed out because of the capital is hosting government facilities and all that. Everyone is coming to the capital city to seek their fortune, build a better life. So these other forests, they are not in the capital city.
So that's where the problem is. When you go to, we have worked with communities for quite a long time. When you go to these communities, they will tell you that they have expanded a lot. The time that the forest reserve the land was taken away from them for forest reserve purposes, it was 1920s, thereabouts. They have expanded. They need also some portion of the forest reserve to do their things. So that's where our fear is. And especially the reason that the president gave to declassify the forest reserve, it did mention two things. The first one is because the land has been encroached. Two, because we did not pay compensation. So that's where the danger is. The point is about 80% to 90% of the forest reserve we have in Ghana here, we haven't paid compensation because the law allows that. And like you have already said, most of them too have also been encroached. Are we not opening the floodgates for those people to also demand that because our forest reserve have been encroached and because compensation have also not been paid, we are also demanding portion of the forest reserve for other developmental projects to plant cocoa, to build houses and do other things. And we think it will be a very dangerous precedent for the president to set.
Okay, let me hold you there and bring in the Honorable Apia Kubi, who is...
there is an issue that my friend is raising about non-payment of compensation in respect of the 1927 acquisition.
Yes.
I want us to, with a kind, permission, go to Honorable Inusa Fuseni.
We'll get to him.
Because if that is the situation, our rendition will be different.
Okay,
but if compensation has been paid, then we will also traverse carefully
the
along
old family
the line.
insists that compensation hasn't been paid.
That is why I want to...
Okay, but I need... Hold on. Just hold on, Mr. Opong. So, Honorable Apia, the question is, why now? Why do this now?
Well,
it's been 20 years. This thing came to former President Kufuor. It wasn't handed over. It went to Professor Mills. Nothing. Why now?
You see, my friend was talking about two modes of acquisition for government in respect of land. And one is the vested land. And it's covered by the law, which has hitherto been repealed by the Constitution Article 268. 267, is that right? Yeah. And also the other one is acquisition. There are two different modes and they come with two different legal perspectives. One of them, acquisition by government, means that all pre-acquisition rights extinguished pursuant to acquisition and pursuant to payment of compensation at the time. And there is a very critical case that the Supreme Court did in Ecological versus Attorney General, who talks about acquisition, and he says that when your land is acquired by government, you lose all rights pre-existing. And the decision in Ecological also says that it affects land pursuant to the promulgation of the 1992 Constitution. It doesn't have retrospective application, which is also in another legal realm. But this land that we are talking about, we need to establish whether it is a vested land or an acquired land. In the case of the 1921 acquisition, I think there is no doubt as to its character, because and it's confirmed by both parties that compensation was paid. But the question I want to be answered is whether or not the £4,000 payment in respect of compensation was to cover both acquisitions, or they are in different legal realms and therefore come under legal two different legal expectations. Now, if Minister answers that question, because I am privy to discussion with him when he said that the payment was in respect of the two. So if that is the case, then the whole family has no case whatsoever. And people talk of compensation. If it had been paid, then why raise compensation? And the laws of the land are that if the land is acquired, you lose all rights. And then there is a case in point, Margaret J. versus Attorney General, which happened in 2014, and under EI 108, and that executive instrument sought to acquire Tema and Accra lands. I'm sure it's under vesting. And there was this lady, the appellant, who happened to have a land within that enclave, had been given by Osu Stool before the promulgation of the executive instrument. And the court says that that was a pre-acquired interest which cannot be subsumed under the EI 108, because at the point of the promulgation of the EI 108, the subject matter was stool land. And at that point, that land, particular land of that applicant, was not stool land, for which reason it could not come under that acquisition, and therefore she was entitled to her land. Pursuant to that, there were also the case of Saka and the Harley, 1984-86 Supreme Court decision, and it says, it confirms that. Then the case of another case comes, Madam Sego versus Snit, and the Supreme Court says that when land is acquired, no matter what time of the acquisition, it covers all. But I think the difference between the two is that this instrument purported to attack all lands, and this one purported to attack stool lands. So the difference is that the woman was saying that my land is not stool land because at the time of publication, it was personal land, not stool land. But in the case of Sego, the court says that irrespective of time frame, once the subject matter, the description and the memorandum talks about a particular land that cannot be excluded from its description, then it means that you will lose it.
Okay.
Subject to payment of compensation.
So there are these varied approaches. Let me bring in the Honorable Inusa Fuseni,
yes,
so that
important.
we can just speak about the 1927 acquisition, because I think the 1921 acquisition is common knowledge. There's an old archival photo of the payment of £4,000. Honorable,
when we get that, then we will deal with it as it is.
All right. Honorable Inusa Fuseni is a former Minister for Lands and Natural Resources, and it was also while he was in office that this issue came up. Thank you very much, Honorable Fuseni, for joining us this morning on TV3 and 3FM's Key Points.
Good morning. And let me say, Good morning to your panelists and my co-contributors.
Thank you. So tell us, was compensation paid to the Owu family at all for the 1927 acquisition? That's the second acquisition.
Well, the Owu family is now contending that compensation was not paid to them for the 1927 acquisition. For me, sitting as minister, I was convinced that
Sorry.
Hello? Okay, unfortunately, we seem to have lost Honorable Fuseni. We'll try and get him
that information
back.
is very critical
Yeah,
to our
but
discussion.
let me now speak with Dr. Godwin Jah. Dr. Godwin Jah is an environmental lawyer, and he's a fellow with York University in Canada. Good morning to you, Dr. Jah. Thanks for joining us. There's been a lot of concern, nonetheless, about this declassification. There's a view that the large tracts of the Achimota forest will remain intact. It's only a portion of it which have been identified. And when journalists visited the forest during the week, they were shown the area. It is a large tract of land bordering offices of the Forestry Commission, which is opposite the N1. So you will see the DSTV offices on the other side of the N1. It is that portion of or tract of land all the way down into Abofu that we are told is handed them. That's one portion that I'm aware of. So now that you know, does this change anything for us?
Thank you very much, Jifa. I hope you can hear me.
Yes,
clearly.
loud and clear. Thank you.
Right. Good morning to your viewers and listeners, and good morning to the co-panelists in the studio and the Honorable Fuseni. I would have wished that the minister had spoken before I proceeded, but we'll take it that according to his point, he made the lands were been paid for. At least that's where he left off.
Only the 1921 acquisition is certain. The 1927 one is not.
That is what he was saying.
Okay, we would even come to that. But generally, we understand that with regards to the acquisition of public lands, and in this context, the Achimota lands, the character of those lands remain a public for public purpose. And I think that that should be the overriding point that we need to address in our discussions. And I'm happy that Elvis flagged that point in his preliminary comments. When we look at the EI 144 and we look at the schedule and we look at the lands that are being affected, the descriptions that followed in the minister's press conference subsequent to the breaking news was to suggest that the lands that are being declassified, at least using the descriptions that he uses, are peripheral lands. That in itself contains a lot of dangerous elements for the sound ecological management of the Achimota forest. Now, for starters, there is a point that we need to make here that a forest reserve, and especially in the character of the Achimota Forest Reserve, serves three purposes: for research purposes, for recreation, and for environmental or ecological purposes. All these three are of public dimensions. Now, to the main issue at hand, when we look at the definition of what the minister refers to as peripheral lands, it takes away the character of buffers. For every forest reserve or for every ecological zone, there's supposed to be buffers around that, because the ecological conditions of the forest or the area require some level of extra protection. And so to take away those lands under the guise or under the description of peripheral areas suggests that they are not relevant to the healthy ecosystem management of the Achimota forest in itself. That, I think, is something that we need to address upfront, that we cannot describe them as peripheral zones, because they're actually integral to the ecosystem of the area. And we'll come shortly to some of the key markers of why we cannot describe them as peripheral areas.
All right. Let's speak to the Honorable Inusa Fuseni now. Hopefully his line will be more stable. Honorable Fuseni, sorry the line dropped a moment ago. I hope you can hear us clearly.
I can hear you clearly here.
Great. So you were telling us about the 1927 acquisition or not?
Yeah, so I said that when I was in office, I had enough information before me to suggest that compensation was paid for the 1921 and 1927 acquisitions. And that when the Owu family appeared before the Alphabetic Committee, it was not on the basis of compensation payment, but it was on the basis of land being returned to them because of the tremendous sacrifices they had made for releasing their land, their family land, for the establishment of the Achimota School and the Achimota Forest. The Achimota Forest itself was constituted into a forest in 1930. So the acquisitions had completed before the forest was established. And so it would be, I mean, it would be news, I mean, to me, for anybody to say that a colonial government will pay compensation for a 1921 acquisition and not pay compensation for a 1927 acquisition, 5 years in between.
So with that in mind, they say that government has not used the land for what they said it would be used for, and hence the land should be returned to them. What's the other opportunity to not do that? Because I think the view for many is that why now? You know, so what's the option?
The government has been using the land for the intended purpose. The 1927 acquisition that was largely constituted into a forest reserve is basically to provide wood for the Achimota School. But we have moved on. We're in modern Ghana. We now use gas. We use electricity. But the wood, to be able to continue to provide wood, you needed to maintain a forest. That was why in 1930, that acquisition was constituted into a forest. And it is still used as a forest. In fact, today we have even a better use for the forest. That forest serves as a carbon sink for Accra. In fact, it's the lungs of the whole of Accra. And so, if you take away the forest, you increase the carbon dioxide in the air because there will not be a carbon sink. It serves to balance the ecological area, the atmospheric conditions of the area. It also says that there has an arboretum, a collection of species of trees that cannot be found anywhere within the precincts of Accra. It has exotic butterflies and creeping reptiles that probably you will not see unless you go to a faraway place. That place, that Achimota forest now serves a better use than even it was earlier conceived. And so there is every reason to protect the forest. There's every reason.
The minister, the Honorable Samuel Abu-Jinapor, insists that the fact that there's been the declassification does not mean that people have sold the forest or people are buying the forest.
So,
what he says is that
when you declassify 245 acres of the Achimota forest, in addition to the 118 acres that was granted under the S.Y. John Dramani Mahama administration, it brings the total number of acreage that will be defoliated, that would be robbed of the forest, to 361.5. That's huge. That's about 40% of the forest. If you take away 40% of the forest, what do you think you are doing to the ecological integrity of the area?
Okay, so let me ask though, the minister says there are portions that have already been leased out to people. They have documents on it. However, they cannot develop the area because of the classification as a forest reserve. Hence, the need to declassify it to allow those with their legitimate lease to develop it. Meanwhile, the larger portion of the forest will remain a forest enclave. That is what the plan is. The minister also indicated that the ecological, the eco park will not happen because they are not convinced of it.
Yeah, so Ghanaians are feeling a righteous indignation because nobody knows what they are going to put the forest, what use they are going to put the forest. And that is why they are willing to give out more than 200 acres of the land to the Owo family. I mean, if a forest is lying fallow, you might as well dissipate it. And that's what they have done. Nature abhors a vacuum. So irrespective of the ecological importance of the forest, they are willing to give out 245 acres of that land. Even Kufuor did not give out that amount of land. Kufuor had entered a memorandum of understanding with the old family to give them 193, and this is scaled it down to 118. This people, the present administration has tripled it, has made it 361.5. Now, so for me, the issue comes down to really why the opposition, why the reversal.
All right.
That's why Ghanaians are right to be skeptical. Is it about an inordinate determination on the part of this administration to grab land? Were we going back to the pre-2009 days when the International Students Hostel was pulled down and petitioned and allocated? When the Minister of Foreign Affairs was taken over, when cantonment lands were sold to persons close to the party? Is that what we're coming back to? Nobody knows. But at least it sounds like that. It looks like that. Because if the first MPP administration under Kufuor had decided, with all the petitions submitted to them, that what the Owo family was entitled to was 193. So if for nothing at all, and you wanted to revise what the NDC had done by scaling it down to 118, what you could do, I mean, to the best of intentions, was probably to up it to what Kufuor had said, that give them 193. Today there is no Kufuor, it's not NDC. It's 245 acres in addition to what was granted.
All right. Let me come to Honorable Apiakubi. So the issue...
Now that we are clear in our minds...
Now that you are clearer...
That compensation has been duly paid. Now then we...
Well, their lawyer doesn't believe so, but I don't want to belabor the point.
It is not the case of his lawyer.
But they've taken a different position, alternative position, which is the land is not being used for the purpose.
Assuming, without admitting that there is no compensation paid, that still does not negate the acquisition of the state of Ghana and the development of the forest. And there is no law that says that when your land is acquired for a purpose, you have to go back and try to reclaim part of the land. No law says that. The law says that upon acquisition and payment thereof of compensation, then your rights are extinguished. And the law continues to say that even where compensation has not been paid, it does not generate a right for you to claim part of that land. But you can go and claim for your compensation. We will not also forget the law of limitation that says that bring your action timelessly. We won't go there. But we will stand on the fact that the law says when the land is acquired for state, for public purpose, it remains so.
We moved on from there, Honorable Apiakubi. The truth is, government has approved this.
The point is that it is only on the failure of purpose that we will go into discussions as to what happens. And even there, if the failure of purpose for the specific purpose fails and the new use is still public interest, public use purpose, then you cannot still say that the purpose has failed. That is the decision of the true. Now, if that is the position of the law, upon what grounds will anybody think of giving any part of the land? I'm not interested in people talking about this EI or President Mahama's purported attempt to divest or President Kufuor's purported attempt to divest. I'm talking about any form of divesting of any part thereof pursuant to the acquisition which is lawful.
But we have to talk about the EI,
No,
Honorable,
I am saying that
I get you if you...
I'm saying that all such attempts are unlawful. That is what I'm saying. So, for me, let the status quo ante remain. That it is a forest land. Simple. And let's, if there will be an improvement of that, giving us additional purpose or additional advantage as a forest, so will it be. But for us to deviate from that purpose and say that because I have compassion for Apiakubi, let me give Apiakubi 1 acre of that land, I think that we will be stepping beyond the law, because the law says that upon acquisition, it stays public land and for public use. So for me, all the brouhaha about how much land, what kind of land use, if the land use is inconsistent with the purpose for which it's acquired, I disagree with it and it's unlawful. And I start from beginning to end, not to treat the end as unlawful and treat the beginning as lawful. All of them, the chain. In fact, if country Ghana, we want to, because this EI is not sustainable, like you were saying. My hometown, Agogo, we also have ceded land to the government. So we also start on compassionate grounds. Give us also back. Do you think that we also don't need a land for agriculture? We do. But if we trigger this, then everybody else is coming. And the whole concept of creating public land will be in jeopardy.
All right. Let me bring in Dr. Jah now. So, Dr. Jah, you've heard Honorable Inusa Fuseini, interesting position taken by the Honorable Apia Kubi. But the truth of the matter is there's an EI. We don't get a sense that it's going to be reversed or rescinded. There are calls for that. The minority in Parliament are demanding that, and an NGO called the Environmental Action Group, led by their convener, Mrs. Va. What do you see looking ahead?
Oh, thank you very much. I've listened to the Honorable Fuseini and Honorable Apia Kubi, and I think that the latter comments by Honorable Apia Kubi are spot on. I prefaced my earlier comments by stating that these lands remain public lands at all times, and for that reason, the public purpose has not abated. The public purpose, as I explained earlier on, and as Honorable Fuseini spoke on earlier, was for research, for recreation, and for ecological purposes. And for that matter, at this very moment that Accra finds itself in the wake of climate change, in the wake of changing global environmental conditions, it's strange that we would take such a decision to cut off nearly 40+% of the forest. At the very least, if we are not adding on to new forests in Accra, looking at the growing population of Accra, at least we should be protecting what we have. And so it brings to the fore serious ecological concerns. I would have wished that the Ministry for Lands and the Forestry Commission would have provided the public with biodiversity assessment reports on the nature of forest loss that we are going to suffer, the kinds of species at risk that are presently going to be affected. These kinds of questions have not been answered in any way by the press conference. Neither have they been. Is there any plan to mitigate that? Just a blanket statement about the intention to protect the ecology is not enough. We know, at least from our recent history, the rezoning of the lands around the motorway and the eventual uses that we've put those lands to. And so we would be shooting ourselves in the foot by assuming that the the best intentions of the minister, as he puts it in his statement, that he concludes by saying they suggested to the president in what he calls the letter to motivate the discretion of the president that we want to create a park that looks like Central Park or Hyde Park in London. Those are not sufficient statements to convince anyone that the public character of those lands will remain the way they are. If anything at all, what the EI 144 suggests to us is that the character of the declassified lands would enter into uses other than ecological uses. That is for sure in the EI 144 as we see it. So it brings to the fore critical questions to be answered, especially in the context of ecological protection, climate change, sustainability. And that's why I was asking whether the media or environmental NGOs have cited or have requested any biodiversity assessment report to support the declassification of this part of the forest and its implications on the total health of that ecological zone. We should not see a forest as just a small part of the forest, but to see the whole ecosystem as it borders on those places that are supposedly declassified. And as I said earlier on, the description as peripheral zones is actually mischievous, and it does not support the understanding of buffers that go with the creation of forest zones. So we need to take a second look at that, and it also brings other critical questions of how we're going to manage other forests, as Honorable Apiakubi raised in his concluding remarks. So these are some of the questions that we need to pay particular attention to going forward.
All right, let me come to Mr. Opong. What next for, coalition of NGOs in the environment? Will you file a petition? I mean, at the end of the day, there are concerns that as a country, this would not be the first time we've seen public lands spirited away under our very noses. So I guess that if really there's a view that this needs to be tackled, what are some of the next steps members may be considering?
Okay, thank you very much. But before I come to the next step, let me address this issue, whether Achimota forest has been sold or not.
Okay.
For me, the bottom line is, it's true, it will be factual that the government is not selling the land. But if government declassify that portion of land and give it to the Owu family, by all means, they will sell it. So whether it's government selling it or Owu family selling it, a portion of Achimota forest will be sold. That's the bottom line. It doesn't.
You hold on, Honorable.
No, so it doesn't matter who is doing the sale. Once that portion is being declassified, by all means, the family will give it to private investors for them to use it.
He wanted to just raise something quickly on that.
I'm saying whether a grant, we are making a grant, and the law prohibits a grant. So whether to family or to anybody, there is a prohibition that you cannot divest any part thereof as per the schedule. Because of the acquisition and because of its classification as public land. So it's not selling, as he's saying, and he thinks that it is only family alone that can sell. But any attempt to divest any part will constitute, in literal terms, selling. Because if we give to our family even for free, we can give a gift. It's still a grant. So it's still a subtraction from the whole. So don't separate the two types of grants. They are the same. You are losing part of that land. And if you lose it, you may give it for free or for pecuniary interest. But the fact of the matter is that it is public land which is not available to be divested to anybody for any interest different from that for which it was acquired.
Okay, I'll come back to you on that. Yes, you said you also had another point you wanted to raise. Yes.
No. So now in terms of strategy, what civil society...
or you don't want to tell us in case government comes to block you? No.
So I can get... I'll not go into details what are the plans are. But what I know for sure is, I think around Thursday, we sent letters to the ministry and last commission demanding for some list of information.
Does it include the biodiversity assessment that Dr. Jha
exactly? And I think we're also looking at the committee that made the recommendation. What was the basis of those recommendations. And there are a lot of information that we are looking for. Once that we have a set of those information, then we will advise ourselves what we need to do.
So you want the ministry to throw sunshine on how they got to this point, how it is that from an initial 118 acres that had been previously agreed, we are at what? Almost what, 300, more than 300 acres, almost double. You want more information about that? But do you plan to speak to the Owu family at all to find out what, their motivation is?
No. So for us, we haven't thought about speaking to them. As a citizen, we have given that mandate to state institutions to manage our public resources for us. So if we have an issue, the person that we need to first talk to is the person we have given the mandate to protect our interest. It's when we get information from people we have given the mandate to protect our interest, then we think that there are gaps that we need to fill it from the Owu's family. Then I think we will do that. Okay.
Yeah. Honorable Apiakubi, yes, I know you've said. I know you've raised this issue about the point you want to make. The point is, the minister has indicated at his press conference, because a similar question was asked about why now. He indicated that people had already have registration documents. The Owu family already had registered documents from the previous committee. Whatever work had been done, they went and registered. People have the lands in there already. So this idea that you cannot divest because it's a public land and all that, that first step has already been
have you
taken.
ever thought of voidable document before?
Pardon me?
Voidable
documents.
Voidable transactions. If any transaction is contrary to law, it is voidable. So I'm saying that I'm not talking about figures. Let's go to 19 something, 118 or something. That which is unlawful is always unlawful. So is it the case that Owu family they had any right to part of the land? If the answer is no, the issue of nemo that could non habet comes in. Who gave it? If the land is vested in the president for and on behalf of the people of Ghana, it is only in fiduciary capacity that the land is vested. So if I'm a trustee and I have your trust property, do I have a right to divest it as a trustee if the purpose is given and I go contrary to that purpose? For me, for once, let us in Ghana say that law must work. Mm-hmm. And therefore, all those purported transactions, can we bring them all to a halt and say, let's go to zero and say that we have a public land acquired for public interest and public interest subsists, and there is no failure of that public interest.
Should the president rescind the EI?
I think so. And the purported acquisitions and the nullification of all such transactions purportedly made between one family and the other, or even the Lands Commission and whoever. You see, because the purpose has not been defeated. In all case law that we have, it is only where the purpose of acquisition is defeated that we look at conditional rights. But the purpose has not been defeated. So why? And even in the case of Tetechuru, it said that it is not the specific purpose upon which the acquisition was made. But if subsequent purpose is still in public interest, then the rights continue to be subsumed. And again, all these case laws are happening post-1992 Constitution. And we are talking of 1927, 19-something. So can we say that the 1992 Constitution, which says that failure of acquisition it brings conditional rights, can we say that it is in effect? Tetechuru has said that 1992 Constitution is not in effect in respect of transactions before 1992 Constitution. It is not only Tetechuru, Ellis and Co. Ellis family versus Attorney General also says that, because Ellis family, the law was created, PNDC law was created in November of 1992, November of 1992. But the Constitution came into effect on the 7th December of 1983. Even there, the Supreme Court says that the law was created before the Constitution, and the Constitution will not have a retrospective application, for which reason the Constitution will not affect that law created in November of 1982. Where are we?
Yes, your thoughts. You wanted to say something
Yeah,
initially
so
before I go back to Dr. Ja.
So I think Honorable made a point that I think we need to re-emphasize. So that argument by the minister that because some portion of the land have already been leased, that's why they need
there are registrations and all that.
You see, there's a reason why, if you even read the minister's statement very well, there's a reason why even when those people went in for the document, they were still not able to develop the site, because Lands Commission realized it was illegal, because you cannot erase structures in forest reserves. So basically, you can have, what they have is a paper which is not void, like a paper which does not exist.
Or cannot work.
Cannot work, that exactly. So what the president seeks to do, the EI seeks to do, was to make that document valid. Without that EI, that document that is not valid. So you cannot say, so that argument that because they already have valid that document, that's why we are doing the EI. Basically, the EI which is rather validating that document that they have.
So do you also feed into the suspicions of many who believe that this is just another way through the back door for senior public officials to benefit from what is the last tract of pristine forest land that we have? Because at the end of the day,
let us not
people don't want to live like me in Ashongman and spend an hour and a half and 2 coming into town.
Let's not even talk about people's perceptions.
No, we must. We must.
Wait a minute.
Because there are unfortunate examples. And I don't want to sound like I'm targeting anyone.
No.
But the truth is, from 2006 to 2007, that was the height of the dispute among the gangs over land. We were fighting and worrying over that one, only to realize that cantonments lands and all those other lands were gone.
If you allowed me, what I'm saying is that let us not even expend energy on people's perceptions, but let's look at the facts and the law as it pertains now.
Perception gives you some insights, sir.
And what I'm saying is that the EI is only targeting land use. It's not targeting title. And what I'm saying is that if you don't have title, land use doesn't matter, because land use comes after title. So the EI is saying that convert the forest use into commercial use. That's all. The summary of the EI is affecting the land use. But what I'm saying is that the more that concept comes in, you must have the land before thinking of the use. And I'm saying that if we situate the law and the facts as at Achimota Forest, the land is not there for anybody to use by the law. So if we attempt to breach that law and give the land, then we will be confronted with this issue of land use, for which people are making attempts to correct so that the land use could be consistent with the planning of the beneficiaries of the grant. And I'm saying I'm attacking even the grant. So we haven't even got into land use to even talk about it. No. So I would suggest and advise that let's shelve the land use matter and deal with, do we have a right to grant? Do they have a right to assess that property before we even think of land use?
All right, Dr. Ja, let me come back to you, because there is the view that this has already been decided. Do you have any ideas about how to overturn it? The specific document writes under it, by command of the president. How can we uncommand the president to change this if he would be so willing?
Thank you very much, Jifa. I think the shorter answer is that it is possible to overturn the command, but before we get there, we need to take a more critical look at the decision that has been made vis-a-vis the power of the president to make that decision. I think that we need to understand that when we look at Article 257 of the Constitution, which talks about public lands broadly, it places that power on the president, which is only exercised for the for the benefit of the Ghanaian community, Ghanaian society, and of citizens of Ghana. And if that is the case, when the decision is made or when the president decides to exercise his discretion under the Forest Act to declassify the Achimota forest, at the very least, we need to see evidence of that level of public consultation that should go with such a decision-making process. I think that there are very many fundamental questions that are yet to be answered at this moment. The exercise of that discretion under the Forest Act is not one that can be made lightly. It's one that has to be made in conjunction with the exercise of discretionary powers under the Constitution. So we need to be able to flag that for review. The second thing that we need to take a look at is that it is possible that Ghanaians in exercise of their right to protect the public interest can proceed to court. Private individuals, traditional rulers, environmental and natural resource NGOs, or any other private citizen who is minded can move in that direction. We should also look at the conduct of the president, because they exercise that discretion in this EI 144 vis-a-vis his obligations internationally and locally, and Ghana's own obligations internationally and locally, his own role at the international level, his involvement in the UN Sustainable Development Goals as the co-chair of the UN SDGs Advocate Platform. These are all critical questions that must be raised in regard to the exercise of this discretion. More importantly is the question that has not been answered, that as of now, the public character of the Achimota forest, that is the lands that have been declassified, have not changed. Like Honorable Apiakubi mentioned earlier on, in the case of the Obichuru case, the Supreme Court went ahead to say that even where the so-called original purpose, public purpose, had changed, if it's still evident that there's a public element involved, then the rights in there are not automatically revived. So at no point in time does this EI tell us that the public character of the Achimota forest land has changed. And for that matter, there should be no reason for us to declassify that. And also, if the argument is that people have already acquired title in quote, which is actually defective or it's non-existent because the public character of those lands have not changed, then we cannot be seen to actually regularize private interest that is irregular only by giving up what is for the benefit of the public. I think that these are critical questions that anybody who wants to take up this in a law court or in other platforms should pay attention to.
Now, Dr. Ajah, I just want to raise with you, you talk about private interests. There's a certain perception, and I have been going through some of our messages, and some of it carried, that this is just a sly way for public officials to seek to benefit from the last pristine tract of land that we have. Honorable Apiakubi says he is targeting the original grant. He is targeting the award. For him, we should deal with that and forget for the moment about land use, because it's only from that land use would be justified or approved. What are your thoughts about that?
Thank you. To an extent, I agree with his concerns that we need to go to the root. But then again, I recall that he made that very important point himself when he said that what the declassification seeks to do, I mean, in very plain language, is to turn part of the forest into a commercial interest. Now, commercial here would also accommodate, in essence, private interest. So whether we address it immediately or we wait till it gets further, those concerns will definitely come up. In any case, if we look at the history, at least our more recent history, in how we rezone lands, and we use the examples of the Achimota, the Accra-Tamamoto Way rezoning process in 2006-2007, which the Supreme Court itself referred to in a couple of judgments, we know that the end game, or seemingly the end game, has always been private interest. howsoever the process starts. So while that may not be the immediate question to be addressed, in the longer term, that question would arise.
Let me read some text messages and WhatsApp messages that have come before us. This one says, it's just a grand design by politicians to loot and grab public lands, hiding behind some families. They are always exploiting loopholes in the system, twisting the laws to advantage just to legitimize illegalities. This one says, good morning. The Ministry of Land and Natural Resources needs to immediately revise the advice they provided that allowed for the declassification of the Achimota forest, assuming they give the land to the family owners now, and the next day another family rises up to reclaim their forefathers' lands, meaning the state is going to lose forest resources which have a purpose to serve the country and the lives of citizens. This one says, I'm disappointed, and his name is Power. This one has no name. It says, Jifa, in the former President Kufuor, Mills and Mahama eras, this same Achimota forest issue came up without much uproar. I think the difference is there's an enormous mistrust by the people of Ghana for this current president and his administration, and it reflected in the passage of the e-levy, and they need to work on restoring the citizens' trust. Theodore from Bando writes, it's quite surprising that those who are required to protect the lives of citizens end up taking actions that don't help the country, and begging the law enforcers to allow due process to prevail in the matter of Nkranta so that people can live a peaceful and comfortable life. Thank you very much for some of your messages. You can send us more to our WhatsApp line and to our Twitter and Facebook pages. Let me turn to the Honorable Apiakubi. You were scoffing at people's perception. It's not me. It's the text messages. And so, but you see, that is my issue sometimes with politicians. Yes, I know. The person puts all of you into one boat. That seems unfair. So, but you see, that is the difficulty of the current. And how can, and I think it goes to the very heart of the current administration and issues when they are raised. They say they are listening government and all these things, but yes, yet the actions do not demonstrate.
No. I'm hopeful that we all will listen, but I don't like the part when you point to the present government. I don't like that, because my submission has not been targeted at any particular regime.
That's someone's message.
What I'm also not,
when I said there's a perception.
Yes, what I'm also not comfortable is when you put us all into one pot and say that politicians. Who am I? I'm one of them. But I am the same person advocating for the opposite. So at least spare us some dignity.
The public should cut you some slack.
Yes, and say that, and not all of us believe in that. Indeed, some of us, by our advocacy, by our conduct, by our preaching, we appear, if you don't even believe, we appear to be championing the public interest. You see, so when you put us all in a box like that, you attempt to bring us by force into that box where we are not. So please, at least say some and save some of us, because we are. There's a growing perception that all politicians are some breed of animals. We are not all the same animals. At least we have dogs and we have cats.
And tigers and lions.
so at least the categorization is important. But be it as it is now, let us all think Ghana. It's important that it is not me or you or anybody else, but is it good for all of us to lose our forest cover? And indeed, you were coming to one point that you should conserve. I will not even preach conservation. I'll preach creation, addition. So our focus is always on conservation. And therefore, Forestry Commission, their focus is all on conserving public lands or forests. But the forests are getting depleted by the day. So it brings us the realization that conservation has not succeeded. And therefore, let's look at creation, adding to it. And here we go. I read something from Brazil. their forestry concept. Brazil forest products, cocoa is classified as forest product. Coffee is classified as forest product in Brazil. I did some research. And in this case, you go to my home country, the forest reserve is all teak. When you look at the economics of teak, it doesn't make sense going into teak production, because when you plant a teak for 18 years, you harvest one and it's only 10 cedis. When you grow cocoa, which is forest product in Brazil, and in 1 year you harvest, you will get not less than 500 cedis a year. Projected that into 18 years. Is it not more profitable? And it gives us the biodiversity and also the forest cover, the same as the teak would do. Even cocoa does it better. So why is it that we are hurting ourselves by crafting a law and taking away cocoa from forest products and saying that you cannot grow cocoa in forest land? And meanwhile, it provides better opportunities than even the teak. So my concept now is that let's amend the Forestry Act to include cocoa and coffee as the Brazilians have done, therefore increasing our productivity at the end of the year, every year, and also giving jobs to our boys and girls to go into cocoa and coffee production, and also on the international scale, on the international market, also increase our market share. But if we don't do that and continue with tick, we are showing disinterest. You go to Agogo and people, you give them tick seedlings to go and plant. They won't, because there's no economic value. But if you give them cocoa seedlings, they will grow and give us what we want as a country in terms of biodiversity and ecology. And then also give money into the pockets of those youthful people. So let's think outside the box and do what the other people have done and benefited from, so that we can also compete equitably on the international market.
All right. Now, Mr. Opon, one of the criticisms I've also heard of the Ministry of Lands and Natural Resources is that you declassify a forest reserve, but yet we are spending more than $12 million to plant trees. The Honorable Apia Kubi is looking at, foresting in his comments. I'm just wondering, should we be spending this much foresting? Should we?
No, so that's a genuine concern from people. How do you spend so much money to nurture seedlings, plant them, protect them, maintain them to mature, when you already have existing one which is matured and you are cutting them down by declassification? So it doesn't make sense. So you are pumping in so much money to increase forest cover somewhere, but meanwhile you are reducing the forest size in another area. In forest we call it net emission. So you cut down forest somewhere and it emits carbon to the atmosphere. Then you plant somewhere and it absorbs it. It doesn't make sense. So for us, we think if we want to improve our forest cover, let's maintain the old ones that we have. Let's improve the integrity, whilst we are looking for other areas, especially in our urban towns. In Ghana here, I think Achimota is the only the bigger urban forestry that we have. Why don't we look for other areas to do urban? And it's not in Ghana alone. When you go to other places like Kenya and other places, people are thinking about...
No, if you go to Ho, they have a forest cover like that.
Yes, we have good forest cover in Ho, but people are attacking the rich.
That is where we have to go.
They are attacking the rich. So when you're on the highway and you see those beautiful,
if you go on
ridges,
the hills and you see Ho, beautiful.
So I wish that is something that would be tackled. Otherwise, very soon the entire ridge will be cut down and there will be hotels.
And Doc, you are in Canada. You are in Toronto, I guess. And look at the forest behind Driftwood Avenue. I lived there for some time, going to York University. Beautiful, isn't it?
Yes.
It has been there years. We want to destroy ours. And in Driftwood Avenue, they are even expanding, aren't they?
Yes.
And they are growing even plants inside even the forest. Driftwood. Yes. You can get a crantia there. Is that not correct?
Yes.
No, exactly. So we should be looking for other avenues to expand even the already existing urban forest that we have. And lucky for us, now there are a lot of innovative ways to even get funding or get revenue from urban forest. Just recently, I think World Bank even gave us some money, I think 50, if I'm right, $50 million for carbon emission. They are doing some projects, FIP project in the Western region. The idea is if you are able to conserve an area and those trees are able to absorb a carbon, they calculate the carbon that is absorbed. The cocoa project. It's you are able to calculate the carbon it has absorbed. Now you have Achimota forest. Why don't you improve the integrity of Achimota forest? Let it absorb the carbon. The trees are there. Then you go there, you take money out of it, and maybe the old family can get their royalties and other. We need to be innovative in our forest.
So there are other ways to give something back to the old family. It doesn't mean that we must give the land back.
Exactly, because like I said, per the arrangement in forest management, if compensations are not paid and government is managing the forest for the people, when a revenue is accrued, royalties are paid to them. So if the current state of Achimota forest, they are not getting revenue, why don't we look for other innovative ways for the forest to generate revenue so that old family can get a sustainable way of getting revenue? Let's assume we give the land to them today. Then they sell the land. The next 10, 20 years, the money...
They'll come back for more.
They will come back for more. But if you improve the integrity and the forest reserve generates revenue, the next 10 years, the 20 years, 30 years, 50 years generation will still be benefiting from such initiatives.
All right. Let me take a final comment from Dr. Ja. Any ideas about how we move forward on this matter?
Thank you, Jifa. I think that I joined the other panelists, especially the comments by Honorable Pierre Kubi that the president should rescind the EI 144. It's not in the public interest, and there's been no other reason advanced to support the EI as it is right now. The points that he makes, the others make about reforestation is spot on. We cannot be engaged in the Greening Ghana project and then actively deforesting one of Ghana's natural forest zones in the city. That also suggests that we are working in contradiction, in contradictory terms. I think also that the idea of carbon rights now, like Elvis was speaking about, are things that communities will begin to engage in the modern sense, where there can be some benefit sharing in terms of these new rights that would emerge with the new uses of forests that we may apply ourselves to. So that is something that we can take a look at, and that will require protecting the forest cover that we have now and adding more to it, where we begin to see more community-based forest areas. And the third thing that I think that we should look at is to bring some pressure to bear on the president in terms of Ghana's commitments at the international level when it comes to climate change, when it comes to our obligations under the Convention on Biodiversity, biological diversity. These are critical documents and treaties that we have signed on to, that we have obligations to obey and to comply with. We cannot be seen to be doing exactly the opposite of those obligations that we've signed on to. I also think that one critical thing that we are not addressing, it seems that we lack a forest practice regulation of a sort, where we should take a second look at how planning foresters, how other professionals engaged in the forestry sector are able to constitute themselves into a regulated practice, properly so-called, just like we see for doctors, lawyers, engineers, and others, that can bring in diversity of opinion. As it is right now, it seems that the carrying force of the discussion is what the Forestry Commission is saying. But if you have a regulated practice, then the likelihood that we have diversity in opinion within the professional body in itself would help us to grow the discussion even further. As it is right now, it seems that what the Forestry Commission or what the ministry says is the standard voice that we should be listening to. But if we encourage that level of engagement as a regulated practice, it will bring diversity of opinion. I think also that when we step away from this discussion, the media also needs to be able to ask some critical questions, as I mentioned earlier on. For example, where are the biodiversity assessment reports for the declassified places in the Achimota forest? Why are we not asking those kinds of questions? In the absence of those questions, it will be difficult for us to carry the discussion forward. You cannot declassify nearly 200 acres of land, natural forest, and not think about the ecological implications, and not show us your mitigation plans, and not show us your relocation plans, and not show us the species at risk plans. All of these are critical components of what we should be seeing in this process. And once these questions cannot be answered, then obviously the decision to declassify the forest would fall into a dark place, and will bring us back to the point where we need to look ourselves in the face and say that the public character of these lands remain as they are, and they should be protected. They are not up for other reasons other than the public interest. These are the questions that I think that we should be addressing.
Thank you very much, Dr. Jai. And Honorable Apiakubi, any final words from you?
I will suggest that we should embark on a program of reforestation seriously. For me, I have already discounted this attempt to divest parts of public lands and consequential effect of the reclassification. I have already dismissed it from my opinion. And I want to suggest that going forward, let's look at reforestation. But looking at reforestation also does not connote keeping ourselves within the confines of the box, what the Forestry Commission says. But what it requires is just a small amendment of the Forestry Act to include also some economic plants that also qualify for the concept of afforestation and the concept of forest cover and the biodiversity. And I have suggested cocoa and what's the name? Coffee. There are people who may also suggest maybe mangoes or oranges, so that apart from the ecological benefits that we are getting from the afforestation, we are also getting economic benefit. This way, we can motivate the youth into such areas, and that will also improve our employment situation. So it is very bad when we confine ourselves to previous concepts and stay in the box. Let's get out of the box, expand our horizon, and also expand our opportunities.
Thank you very much, gentlemen. Many thanks to you, Mr. Pong, spokesperson for the Coalition of Environmental NGOs. Many thanks to the Honorable Andy Apiakubi. Many thanks to Dr. Ja joining us all the way from Canada. Much appreciated. And thanks to all of you for watching. For those of you who sent us WhatsApp, text, Twitter messages, Facebook messages, much appreciated. And my entire thanks to the production team and our cameramen here. Up next, of course, is Kids Arena. You've been watching Key Points live from TV3 and on 3FM 92.7. Enjoy the rest of your day and watch Kids Arena. Have a good day.